Good afternoon, ladies and gentlemen.
And then I fixed it all.
I'm Gary Bergosh. I'm a retired circuit court judge from the First Judicial Circuit of Florida, and I'm the president of the Emerald Coast Federalist Society chapter, which is out of Pensacola, Florida as well. It is my distinct honor to introduce our moderator for this afternoon. Our moderator is the Honorable Kent Weatherall. He's a judge in the Northern District of Florida, federal judge. Judge Weatherall has served as the United States District Court judge for the Northern District of Florida since July of 2019. He previously served as an appellate court judge on the First District Court of Appeal from 2009 until 2019, and he was an administrative judge with the Florida Division of Administrative Hearings from 2002 to 2009. Before becoming a judge, he worked as an attorney both in the public sector and the private sector. Judge Weatherall received both his undergraduate and his law degrees from Florida State University. Ladies and gentlemen, help me welcome Judge Kent Weatherall.
Thank you, Gary, for that introduction, and thank you to the Federalist Society for inviting me to moderate this panel. Now, federal judicial appointments get more press than state judicial appointments. However, a good argument can be made that the composition of the state courts are more important than the composition of the federal courts, because federal courts, as you know, are courts of limited jurisdiction, and the vast majority of litigation occurs in the state courts. Also, the efficiency and fairness of the state's judicial system can help attract and retain businesses in the state. In Florida, as you all know, judges are appointed by the governor from lists submitted by the judicial nominating commissions. And in Florida, we have now had Republican governors for more than 25 years. Governor Bush and the Republican governors that followed him shared the view that the role of the judiciary is to say what the law is, not what it should be. And for the most part, that is the kind of judges that these governors have appointed. But as Governor Bush told you a little bit ago, it took a while for the fruits of those efforts to come to fruition. When I joined the first DCA in 2009, which was more than a decade after Governor Bush took office, 7 of the 15 judges had been appointed by Democratic governors. And one of the 8 judges who had been appointed by a Republican governor was Judge Nikki Clark. He was a very nice person, but not someone anyone would think of as a textualist or an originalist. By the time I left the first DCA in 2019, all 15 judges had been appointed by Republican governors. Now, that did not mean we always saw things the same way. In fact, we didn't. There were an inordinate number of in-bank cases that we had at the first DCA. But by the end of my time on the court, those cases and the dissents that were written were driven more by disagreements over the law than the differences over the proper interpretation of the law, rather than philosophical differences about the role of the court vis-a-vis the policy-making branches. The same thing that we saw at the first DCA occurred throughout the state. Today, in addition to the first DCA, every judge on the 3rd, 5th, and 6th DCA were appointed by a Republican governor. And by my count, there are only 2 judges that are still serving on the DCAs that were appointed by a Democrat governor. I want to pause for a moment and clarify that when I refer to judges appointed by Republican governors and judges appointed by Democratic governors, I am not suggesting that there are Democrat judges and Republican judges. In fact, I firmly believe that the vast majority of state court judges, whether appointed by Republicans or Democrats, are deciding cases based upon the law, not their political affiliation or the political affiliation of their governors. And for those of us who were appointed by Governor Crist, that is a very good thing because his political affiliation changed over time. Now that said, I do think, and I think Governor Bush touched on this, that governors typically appoint judges who have similar judicial philosophies that they do. For example, a prospective judge who believes that the intent or purpose of the law reflected in its legislative intent should control over the plain and ordinary meaning of the text of the law, that the Constitution is a living document and that new rights can be found in its penumbras if you look hard enough, would probably have a better chance of getting appointed by a Democrat governor than a Republican governor. Thus, the political affiliation of a governor is a rough, albeit imperfect, proxy for the judicial philosophy of a judge. Now, the shift that occurred at the DCAs is even more pronounced at the Supreme Court. In 2009, although there was nominally a 4-3 split between Republican and Democrat-appointed justices, for all practical purposes, there was a 5-2 liberal majority on the court. Because despite Jason Gonzalez's best efforts as general counsel for Governor Crist, two of the justices that Governor Crist appointed, Justices LaBarga and Justice Perry, were quite liberal. Now, as an aside, the 2009 to 2019 Supreme Court is sometimes referred to as the Gonzalez Court, because as general counsel, Jason was responsible for appointing a majority of that court. Justices LaBarga, Justice Perry, Justice Kennedy, and Justice Polston. So if you're unhappy with any of the decisions that occurred during that period, you have Jason to thank.
Is there a gong? I love this introduction.
At least he batted 500.
Now, on the Gonzalez Court, Justices Kennedy and Polston spent most of their days writing dissents, which had to be just miserable. But when those of us on the DCAs who shared the judicial philosophy of Justice Kennedy and Justice Polston received 5-2 reversals, we considered them to be badges of honor. Today, the Florida Supreme Court has a strong originalist and textualist 6-1 majority, led by Justice Kennedy's protege, Chief Justice Carlo Muniz. Governor DeSantis has appointed 5 of the 7 justices on the current court and 7 justices overall, including 2 judges who now grade my papers, 11th Circuit Judges Luck and Lagoa. And if you think about that, that is pretty remarkable. It's akin to the 8 U.S. Supreme Court justices that President Roosevelt appointed in his 12 years in office. Now, the new, and some might say improved, Supreme Court has been busy undoing some of the bad precedent from the Gonzalez Court era in both criminal and civil law. Among other things, the court has reinterpreted the right to privacy clause in the Florida Constitution, eliminated proportionality review in death penalty cases, narrowed the scope of its conflict jurisdiction, emphasized the textualist standard for statutory interpretation, adopted the federal summary judgment standard, replaced Frye with Daubert, and overhauled the rules of civil procedure to speed up civil litigation. Now, the panel we've assembled today will talk to us about the transformation of the Florida courts that occurred over the past 25 years that led to these and other developments in Florida law, and they are eminently qualified to do so. I'm not going to go through each panelist's impressive biographies because they are all well known to this group. The key part of their biographies for purposes of this panel is that each panelist was a general counsel for one of the past 4 governors. Rocky Rodriguez, who you met earlier, general counsel to Governor Bush. Jason Gonzalez, who I've told you about, was general counsel for Governor Crist. Dan Nordby and Jesse Panuccio, general counsels for Governor Scott. And Ryan Newman, the current general counsel for Governor DeSantis. Now, we've got a lot to cover in a relatively short time. We're going to do our best to save time at the end for your questions. But with that, Rocky, let's go back to 1999 when Governor Bush came into office. You talked about this some with the governor, but one of the biggest hurdles that he faced when appointing the type of judges that he wanted was that the JNCs were controlled by the bar. By the time you joined the governor's office in 2002, the legislature had amended the JNC statute to give the governor more authority, but that didn't solve all the problems immediately. So if you'll talk to us a little bit about the additional issues that you had with the JNCs, the slates that they would send up of the JNC members, the nominees themselves, the rules, and how you overcame those issues.
Absolutely. Thank you, Judge Weatherall. I think that was a really great background, and at least Jason batted 500, so we can't hold it too much against him. And he wasn't all in his control. So I came in at the end of 2002, just after Governor Bush was reelected, and by then the JNC reform had been in place for about a year. As you recall from my conversation with Governor Bush, and many of you already know, the JNC commissioners have staggered terms. So you might get a couple of fresh faces, a few fresh faces every year, maybe one per JNC. but it was going to take a while, and we slogged through it through the end of his term. But in the meantime, while the old guard was still mostly in control, especially because the chair of the JNC is basically you serve for a while, and then you become the vice chair, and then you become the chair, and it was very hierarchical. And we already had in place the Judicial Nominating Procedure Committee from the Florida Bar that had created the rules in conjunction with all of these appointees appointed under the old statutes. There were a number of procedures in place that also made it difficult to get nominees through. But I would say one of the biggest barriers in the beginning to getting a broad group of nominees for the court was some of the gamesmanship that not all, but a few of the JNCs would engage in. And as I mentioned earlier, the minimum that can be nominated to the governor is 3. The maximum is 6. Well, a lot of the JNCs, especially in some of the smaller counties, would nominate only 3. And in some cases, it would be 2 really horrible people that they knew would never get appointed or thought they would never get appointed, then somebody that was actually competent but probably did not share the governor's philosophy. So that would put the governor in a very difficult bind. It would put us in a bind, but they complied with the law. And once in a while we would throw a letter back and say, "You had all these applicants. Can't you do better?" And whenever there was a vacancy in office, I would send out a letter under the governor's signature convening the JNC, and he would specify that he really wanted the maximum number of nominees, and he wanted them to represent a broad spectrum of the state in all of the different ways that Governor Bush described earlier. And we would even actively participate in the training of the JNCs to try to build up that philosophy. Another way that some of the JNCs would try to limit the governor's choices, and I remember one in particular, one JNC where they had 3 vacancies at once. And they sent out a slate of maybe 3 or 4 of the same people for each vacancy. And when you did the math, it did not yield a minimum of 3 nominees for each vacancy. And if you just looked at them in isolation, oh, we complied, but it really did not account to that. So that one, the governor sent it back, and he finally got another list of 6 for each. Still, 6, 6, 6, same names, but at least he had a little bit more to choose from. And so that another one where they didn't really stick to the schedule for the submission of applications, and they had it posted in one place but not another, and they got very few applicants, and they only sent the 3, and the governor said, "You need to do a do-over," and somehow they did. So those were a lot of the issues that we faced with the JNCs, and but we eventually worked through it, and I think we got a really good group of judges appointed despite those efforts. You couldn't get 100% success because you didn't have 100% to work with. But I think, I have confidence, at least in the time I was there for 4 years, I felt good about the appointments that he was able to make.
Well, Jason, that brings us to Governor Crist, and I've heard from reliable sources that you followed judicial appointments as far back as your high school years. And there's no question that you've played a large role in the growth of the conservative legal movement in Florida over the past 30 years as an attorney. So talk to us about what you've seen and experienced over that time.
Sure, and after that flattering introduction, I have to ask, does anybody want to buy a law firm? I see everybody's got a lot of notes up here. I don't have any notes because in the Crist administration we really didn't accomplish anything. But I knew I was coming here to be the object of Charlie Crist jokes, and that's perfectly appropriate. But yes, I have kind of been the Forrest Gump of Tallahassee politics. 3 generations of my family in Tallahassee, and Dad raised me around all of it. And I remembered when my dad was the first director of the Commission on Ethics, and they declared it unconstitutional. And I remember as a 4-year-old dad at the table, pounding the table about the judicial activist judges legislating from the bench. So those were some of my earliest memories. But I had the privilege of watching, Carol Licko and Daniel Woodring, who was an extraordinary force in the earliest years of the Bush administration in this process of getting these courts on track. And Charles Kennedy and Rocky, and watching what they did in those early years and with the reforms in 2001, that got everything started. That's the only reason we probably wouldn't be having this conference today if those 2001 reforms were not done. And echoing on, you heard Daniel earlier in his introductions talking about the situation with Lou Huebner, the first District Court of Appeal. JNC didn't even give this incredibly qualified Deputy Solicitor General an interview. And Rocky mentioned some of the games those Florida Bar dominated, Florida Bar Board of Governors handpicked dominated JNC's, the games they were playing prior to 2001. And I remember, I think it was the 14th Circuit vacancy where you had, they tried to tie the governor's hands with 3 nominees, and I think one of them was under criminal investigation at the time. Another one was not under criminal investigation, but he'd been convicted of a DUI, and he got the DUI on the way home from the courthouse after a hearing. And then they had the preferred candidate that the Good Old Boy Network wanted for that vacancy, and that was the sort of thing that was going on. So these were very critical reforms, knowing how things work in the Florida legislature. I still don't know how Governor Bush's team got with the power that the Florida Bar had in the legislature at that time. I'm in awe that they were able to get those reforms done. But that is the reason all the good things that are happening today have happened. And it would be my preference that we completely take the bar nomination process out of the JNCs, because again, the people of Florida don't elect the Florida Bar Board of Governors. Most people don't even know who their Board of Governors members are. Honestly, I have no idea who the Second Circuit Board of Governors members are. I just don't. I think the buck stops with the governor on these appointments, and it ought to go to a system where he gets to appoint, or she gets to appoint, all of the members. And at some point, about 15 years ago, we ran an analysis to see, okay, we suspect there's pretty dramatic political leanings of this group that is controlling the selection process for an entire branch of government, and they're not elected by the people. Are there political leaning issues? And we found in that analysis, 89% of the members of the Board of Governors were either registered Democrat donors, or NPA or Republicans that were major donors to Democrats. So there was no hiding that it was way outside the mainstream, very skewed operation that was getting to pick all the JNC, 3 of the JNC members, and then they would have the governor's 3, and they would always inevitably be able to control who was picked for the other 3 in that process. So it was just not something that led to a judiciary that was reflected what our governors and the people of Florida would have wanted.
Well, after the Crist era ends, we begin there with Governor Scott. And Jesse, y'all might want to get your popcorn ready for this. So Jesse, you've been able to have before you the 12 years of Governor Bush's work, Jason's work with Governor Crist, and so one would think that made your job as general counsel for Governor Scott very easy in selecting judges, and that at this point all the work is done. So is it?
Well, thanks, Judge, and thanks to everyone on this panel. And I just want to start out by saying thanks to Governor Bush for being here, because as others have said, I think everything that we've done since really started with him. And his GCs and his team, and they showed great courage at the time in doing what they did. And they put in place reforms, a framework that allowed subsequent governors and subsequent GC offices to really flourish. And a lot of people in this room are the beneficiaries of that. So thanks to all of them. When we came in, so it's 2011, Charlie Trippi, who I think I see out there, was first GC to Governor Scott, and I was his deputy. And, you know, a lot had been done, but if you just think about the ages of everyone on the bench and how long they can stay, we still inherited a judiciary at that time that really was made up of a lot of people that still came out of that framework that Governor Bush was talking about, this sort of 1970s era, you know, very left-wing Florida bar view of courts and how they should approach the law, and this kind of idea that if you had these independent people on nominating commissions, you'd get the ideal judge out of it, and there's no politics involved in that at all, which is, of course, you know, malarkey. So when we looked at these JNCs, and Charlie and I remember we looked at this, and I was new to Florida at the time, and I said, well, who are what is this law firm Morgan & Morgan, and why is everyone on the JNC from there? Found out that Governor Crist had taken a job at that law firm, so make of that what you will. You know, and the Florida Supreme Court was still one of the most left-wing in the country, no doubt about it at the time, due to some, you know, unfortunate retirements and some, you know, Charlie Brown with the football, as Republicans always do with their appointments. And by the way, I want to note a side note, you know, this was a constraining factor. If you think about the governorships and policy things that can get done, you know, Governor Bush, early Governor Crist, Governor Scott, they were always laboring under the you know, notion that at the end of it was going to be this Florida Supreme Court that very predictably, if they didn't like the policy, they were going to strike it down. And, you know, contrast that today when it's a much fairer shake up there on the policy. So it does matter on the ground. But, you know, our approach was powers that Governor Bush had. You heard about what he got through the legislature, but they hadn't been fully fleshed out yet. You know, they got put in place, and it was very important. And I think when we came in, Charlie and myself and others who followed said, okay, we're going to start to use these. And so I remember the first time Governor Scott rejected a bar list for the JNC for the first time ever. And you would think, I mean, we had to do rounds of negotiation. It was like papal visits from the Florida bar president to the governor's office when we were going to do this. Now, Ryan, they do it all the time. But back then, it was quite a big deal. We also, for the first time, began interviewing every single person applying to be on a JNC. It was critically important. We wanted to know who was getting appointed. What did they think? Did they share the governor's vision? It was a ton of work, and I remember Charlie said he had us all in that little library in the governor's office, and he said, we're going to do this brick by brick, house by house across the state. Now, there's 20 some odd JNCs. They have 9 people each. These are hundreds of interviews in a shop that had 6 lawyers. So we did this stuff night and day. We also interviewed every judicial applicant. We gave them all a half hour every time. We wanted to hear about them. We were looking not just for judicial philosophy, but intellect. We were looking for reputation in the community. We were looking for courage under fire. All of these things were important, and we tried to come up with a process to get to that. I don't have enough time, and I can tell you some funny stories from the time, you know, about what we had to do to wrest control of these JNCs. The 4th DCA was a great example. I remember when that court flipped and what we had to do. And I remember the person we put on the JNC who was the deciding factor. And I told them, I said, here's what they do now that they're losing control of the bar. They go in, they try to change the rules of the JNC so that it's not a majority vote anymore. I said, you have to resist that. There's a statute that says very clearly, 5 members of the JNC decide who's on that list. And every time they yell at you, I want you to point to that statute, and I want you to say, here's the statute. I'm calling for a vote. We're taking that person off the list and putting this person on. And he did that, and the meeting lasted 10 hours, and we got the nominees we wanted, and that court flipped. It was a very substantial time in the office. I remember that. So we've accomplished a lot in 25 years, a lot, and I think everybody on the stage will share that message. Now, I want to close with something a little different, which is to say, you know, I get the sense when I talk to people in this room, we've kind of reached this end of history moment, like, well, we've done it. We've reformed the Florida judiciary and we're done. And that's not true, and it's not true for 2 reasons. One, it's a really fragile thing. We're one governor, we're one general counsel away from it all going the other way, right? People retire, they leave, they move on in their career, they get appointed from one court to another court to the federal bench. And so the vigilance has to be there, the people in this room, the people in this network. One of the things we did in the early Scott years, and Jason was there, was we started this conference. The point of this conference was to be able to have this network and make sure we're vigilant on this. But I also just want to caution against the idea that even now we're done and everything is hunky-dory. There are things that still need to happen in terms of judicial reform in our state, and I'll just close with that. One of them is, Jason mentioned the Florida bar. It is shocking to me that 6 years after we changed the Florida Supreme Court, we are still laboring under a unified bar in this state. I personally don't want to, and I know many other conservatives that don't want to either. I am fine to be a member of an association that run by the Supreme Court that certifies my license and does my CLE and does the discipline, but I really don't want to be a part of the political organization that's known as the Florida Bar, and I don't understand why the court won't take action. It's time. It's time. They don't need to wait for someone to bring a case. They can do it on their own motion. They've done a lot, and I think the court should do it. It is time. We're 6 years into this. Two, I think, and I bet the trial judges would agree with me, I think the legislature ought to look at pouring a lot more resources into our trial courts. I think they need law clerks. I think they need more staff support. And that's from a private lawyer's perspective. We have these great business divisions around the state, but I'm there and the judges are overwhelmed and they need time and they need support. And instead of creating, I'm sorry to my friends, a DCA that we didn't need and putting 12 new judges, we could have put that money into the circuit courts and it would have done a lot more for the people around the state who rely on the judiciary. My own view, but I bet it's shared by the clients, the people who litigate around the state. And then lastly, I will say about the DCAs, everybody knows if they've been before me on a JNC, I ask this every time, what's your view of PCAs? What's your view of, the right time for an opinion? We still have appellate courts that put out an inordinate amount of PCAs in cases that deserve decisions or at least some reasoning. And sometimes the decisions take 2 and 3 years. And I just would urge judges out there, for those of us who have clients, if clients don't get a decision for years or they don't get reasoning for the decision, judicial reform means nothing to them. They don't think the courts have reformed at all because they don't know why their case was decided the way it was decided, and they don't know why it's not getting decided. And so it would be nice if we could have some systems in place that sort of move these cases along through the appellate courts of decision, because it does matter to the people that the justice system is actually for in this state. And then the last thing I'll say is, look, as a matter of judicial philosophy, I do not think we've reached nirvana yet. I will just give you 2 examples from our high court that I think were wrong. They were very wrongly decided and they mattered greatly. One was the decision, Thompson versus Francis, the first appointment of now Justice Francis, where the question was a critical question of gubernatorial appointment power. And it was very clear in the text of the Constitution that it's holding office that requires 10 years in the bar, not appointment. And the court swept that aside. They swept aside a controlling precedent, and they said, we're just not going to have it. That did not, to me, look like robust textualism. And worse still, they allowed a exercise of quo warranto, and they cited as the worst precedent from the last 15 years, Wiley v. Scott, as good precedent. And they said, you can challenge this through quo warranto. 3 years later, another opinion comes out called West Flagler, and the court said that's not a proper use of quo warranto anymore. You can't use quo warranto to challenge the way an official carries out their duties. And so it was really jarring to see a court that sort of wove around to get to this result that I think if you were looking at it as a pure textualist and adherence to precedent, you wouldn't have got there. And the other decision, I can't let a panel on judicial reform go by without mentioning this, the ballot decisions from last year, particularly the Amendment 4 decision, at least for me, and I think others in this room, were stark. The court basically said, so long as a proposed ballot amendment summary follows the text exactly of the proposed amendment, we have no job as a court for judicial review. And if you actually play that out, if you had a ballot measure that said the right to purple meatloaf on Thursday shall be inviolate, they would let that on the ballot as long as you repeat it on the summary. It doesn't make any sense. And so it sort of gutted judicial review, and it gutted it on the most important fundamental issue to judicial conservatives and conservatives. I thought it was I thought it was a moment that really, for me, said we are not there yet on judicial reform. So, In sum, we've done a lot of great stuff happened, but there is more to go, and I'm looking forward to the next 25 years.
The views expressed on this panel.
Are purely my own.
Dan, you followed Jesse in Governor Scott's administration. Jesse seems to see the glass half empty. Do you agree, or is it half full as compared to where we started?
Well, thank you, Judge, and appreciate the Federalist Society and other members of the panel here. I came into the job in April of 2017 to finish out the last 20 months of Governor Scott's second term. And compared to Rocky's efforts to implement the JNC reform, Jason's client management issues that he had to overcome, and Jesse and Charlie Trippy's work to repopulate the JNCs with commissioners who saw their job as to assist the governor in the appointment power rather than to oppose the governor. I was there during what I would say is relatively a golden age for judicial appointments. My first week on the job, I attended the investiture of future Justice Robert Luck to the 3rd DCA. My last day in the job was the appointment of future Justice Meredith Sasso to the 5th DCA. And in between those two bookends, we had the county and circuit court appointments of future Justice Renatha Francis and the county and district court appointments of future Justice Jamie Grosshans. So we had a good run during our time. But I agree with Jesse in general that the work's not done. There's still work to do. I think the process is never done, and it should never be done. Our biggest challenge during my time in the governor's legal office wasn't with the legislature or really with the Florida bar. It was with the courts themselves. Part of my charge to finish out Governor Scott's term was to set the stage for the appointments of the replacements for Justices Perriente, Quince, and Lewis. At the time, the Florida Constitution provided for mandatory retirement of justices and judges when they reached the age of 70, but if they were more than halfway through a 6-year term, they got to finish out that term. And as the birthdays and the calendars fell, Justices Perriente, Quince, and Lewis all turned 70 years old during the second half of their 6-year terms, so that their terms ended the same day and the same time as Governor Scott's second term. So we were in the same situation that Governor Bush faced when he came into office, with a dispute over, or a potential dispute at least, over whether the incoming or outgoing governor was entitled to make those judicial appointments. Now, our working assumption was that in the past, Governor Childs and Governor Bush had worked it out, that they'd had a list provided from the JNC well in advance of Inauguration Day. They met, they conferred, as you heard from Governor Bush, and they came to at least an agreement not to disagree on who that selection was. Governor Childs made the appointment in December before his untimely passing in December, and then Governor Bush elected not to challenge that appointment when he came into office. So our assumption was that was at least a constitutionally permissible process for this dispute to play out. The League of Women Voters of Florida had different ideas. So they sued in quo warranto in June of 2017 for a determination from the Florida Supreme Court that Governor Scott, unlike Governor Childs, lacked the authority to make an appointment for these judicial positions. Our office quickly defended that the quo warranto petition, both on the merits, that governors routinely make prospective appointments for vacancies that are known to occur in the future, and we'd also raised some jurisdictional and prudential arguments. In particular, we attacked what was at that time a relatively novel use of taxpayer standing in quo warranto actions, which has continued since then, as you heard from Jesse. And we also made some prudential arguments. There was a case in the 1950s where an outgoing governor appointed a county court judge because the incoming governor wasn't sworn in until noon, and the outgoing governor made the appointment before the incoming governor was chosen. So, we had some merits arguments as well as some jurisdictional and prudential arguments. At the time, the Florida Supreme Court, with 4 justices, bought the last of our arguments, a ripeness argument. They said, Governor Scott hasn't done anything yet, so therefore we have no occasion to weigh in yet. But there were concurring and dissenting opinions that suggested strongly that Should this come up again at a later time, they would be prepared to decide the case and potentially decide it in a way adverse to the outgoing governor's appointment power. We had a second case involving the the authority of the governor to appoint judges to the trial courts, whether those appointments should occur through, whether those judicial selections should occur through the election process or through the appointment process. That was a case where a trial judge in Leon County just blatantly disregarded controlling first DCA precedent. It went up on appeal. The first DCA affirmed their prior precedent on that the governor was able to appoint as to vacancies that occurred before the candidate qualifying period. But then the Florida Supreme Court came in with an all writs petition blocking the appointment process and taking jurisdiction, which was a pretty ominous sign as to the history of what that precedent would be. After argument in that case and after the election had occurred, the Florida Supreme Court discharged jurisdiction in the case and let the first DCA precedent stand on that, affirming the governor's appointment power. And then the last case that we dealt with on the governor's appointment power was the return of the League of Women Voters of Florida, where they came back in after the governor asked the JNC to convene and to begin the nomination process on precisely the same schedule that Governor Childs had 20 years earlier, and to recommend names to him. Another quo warranto emergency lawsuit in the Florida Supreme Court that requested not only that the governor not be allowed to make the appointments, but that the JNC not be allowed to begin its process until a new governor was elected. If you'll recall, in September and October of 2018, it was far from clear who the next governor would be, but the public polling at least suggested that it may not have been Governor DeSantis. So the Supreme Court in that case issued a kind of an odd unsigned opinion saying Governor Scott doesn't get to make these selections, and we're going to have oral argument 2 days after Election Day on whether the JNC can continue through its process. Election night comes, and much to many people's surprise, Governor DeSantis won a very close election, and thank God for that. So at the oral argument 2 days later, we had a rather glum counsel for the League of Women Voters of Florida making the argument that only Governor-elect DeSantis could make these elections, which warmed my heart a bit. And the Supreme Court ultimately said that the JNC could indeed begin its process, just as it had many, many times over the past 50 years, to avoid physical vacancies of 3 justices on the court for the entire time period before the process could play out if they were not allowed to begin until Inauguration Day itself. So, with that, Governor Scott left office, and Judge Wetherall alluded to it earlier, having 35 of the 64 DCA judges at the end of Governor Scott's term had been appointed by Governor Scott. So more than half of the DCA judges during that 8-year term, out of a total of 406 judicial appointments. So I think during those 8 years, we were finally able to see the culmination of some of those reforms that began with Rocky and with Daniel and with Governor Bush, and I think those were a critical foundation for what ultimately led to these reforms in the judicial process. And then handed it off to Ryan and some of his predecessors in the office then.
Well, that then does bring us to Governor DeSantis and Ryan as his current general counsel. And Ryan, it seems like you've benefited greatly by 2 main things. One, the growth of the conservative legal movement that this body represents, as well as the foundation that Governor Bush and the subsequent governors have laid in the appointment process and the JNC process. So is that the case? And if so, what challenges have you had and what issues do you see moving forward?
Well, that's no doubt the case. I'm mostly here because I wanted to listen to my predecessors. I felt like I owe so much to them and the work they did in getting this whole process up and running. In fact, as I was listening to all the fights and difficulties that they faced, it sort of dawned on me that they must have devoted so much of their time to this effort. And indeed, while we in my office do spend a lot of time on judges, having a process that works and functions effectively, having a conservative legal movement in place from which to draw appointments really frees us up to, I don't know, pick fights with Disney or with the legislature. I hope everybody is enjoying the Central Florida Tourism Oversight District. Welcome. We're friends again. Everything is good now. No, it's interesting because I'm not from this state. Didn't really know much about this state until I showed up to be the governor's general counsel and had to take the bar exam, in fact. But before that, I spent so much time in D.C. I was chief counsel to Senator Cruz on the Senate Judiciary Committee. I was the head of the Office of Legal Policy at the Department of Justice. Both of those jobs, focus a lot on judicial appointments and judicial selection at the federal level. And I look across states right now, and we have litigation, in other states, in Alabama and so forth, and we lose in front of Trump judges, and that shouldn't happen. Well, the reason why that is because there's this thing called the United States Senate. And the United States Senate becomes a real problem it can be a real problem for getting the right people into federal judicial office. That's not the case here. So when I came here, I thought, man, this system is awesome. This is unbelievable. You mean, the governor just gets to pick from this list and that's it? We don't have to go sell this to anybody else or get it approved by the Senate or anybody in the legislature. And I thought, this is amazing, and it is a very potent system, and I think one of the best systems in the country, and it's proving, I think, to be that way. But it really is only so good as the governor who sits in the chief executive office. It's the governor that sets the direction for judicial appointments. And if you don't have the right person in that office, this thing can go off the rails real quick. So it's absolutely critical to have a governor who is focused on this, who sees the importance of judicial selection, who understands that the judicial role is a limited one, and that judges should adhere to the original public meaning of the legal texts that they're interpreting, and that is absolutely critical. Now, I will say, we were talking about the bar. I have to confess, and I hope nobody starts working on my disbarment papers or something. But I really don't communicate much with the bar. We don't. So it was interesting listening to some of my predecessors talk about having meetings with the grand poobah of the bar. We just don't do that. Yes, we understand that they nominate people for 4 of the spots on the JNC, and we work with them at lower levels, but we don't really interface with them too much. And if there's a list that we don't like, we'll either sit on it or reject it until we get candidates that we like for the JNCs. Now, we talk a lot about picking the judges, but the JNCs do play an important role in the process, and so the governor's office has to be cognizant of that and put effort into selecting the right people for the JNCs, and that's where a lot of you come in. Some of you sit on JNCs here. So a lot of you help provide tips to us and on-the-ground information about candidates for JNCs, and that's absolutely critical because we want the JNCs to also adhere to the same judicial philosophy that we're looking for in our appointments to the bench. It's absolutely critical. But one of the things that I think is just so great about this system is it really does free up the governor's office to put aside politics. And if you have the right governor in place, it's not a transactional thing. We can actually make appointments based on the quality of the candidates and their commitment to the judicial philosophy that we believe is the correct judicial philosophy for people sitting on the bench. And that's what we've tried to do and the DeSantis administration. And I've said this many times before, we're looking for people who fly their colors. We're not trying to find a candidate that we can slip by, a JNC, or that we can slip by the public or the press, or that we can slip by, other politicians in the state. We do not care about that at all. And in fact, it's a knock against you if I can't look at your record and see somebody who's committed to what we're talking about here. If I can't see it in your record, you will not get appointed by this administration. And just to sort of underscore the kind of mentality that Governor DeSantis has about this, there was a judge, Jared Smith, who was a circuit judge in Hillsborough County, and he denied a judicial bypass to a minor who was seeking to obtain an abortion. And so the left decided that they were going to put effort into getting him knocked off the court in an election. And they succeeded. They focused on him in Hillsborough County, and they got him booted off the court. So what did Governor DeSantis do? He appointed him to the 6th DCA, right? But that's what we're looking for. We're looking for people who do the right thing. And if they do the right thing, they will be rewarded by this administration. If you've got to fly your colors. That's what we're looking for. If you spend your whole life in a law firm doing business cases, as admirable as that is, okay, that's going to be, you still might get on the court. You still might but we're looking for so much more than that. You got to take some time out of your career to go serve in government. Do something that could cost you something. Take a stand. That's what we're looking for. No more, trying to read tea leaves in people's backgrounds. We're done with it. We're done with it. And this process allows us to do it that way. And so I want to thank my predecessors for all that they've done to tee things up where we can do what we're doing here. It's certainly made my life a lot easier. As far as, things, it was interesting hearing Rocky talk about, some of the challenges she faces with the JNCs. We still face some of those challenges, no doubt. I mean, there are some circuits in the state where they do try to cabin the governor's choice, and you can tell the games that they play. And, if we do suspect that a JNC is playing those games, we look for the next opportunity to fire people and put somebody else on there. The other challenge that we still face, even, as the conservative legal movement grows, it becomes a bigger tent. It does get a little bit more difficult to determine, who's really committed or who's doing this because they know that to get an appointment in this state, well, this is the box you got to check. And it is remarkable when we do interviews. Everybody is thoroughly read Scalia's Reading Law, and gives us the same answers. And of course, we try to ask more probing questions to figure out, how committed are the candidates to these particular ideas. That being said, the mere fact that people think they need to do that is itself success, right? Because I do think that, as people are exposed to these ideas that have been developed over time, and they will see the value in them. They'll see the correctness in them, and people will begin to internalize it and believe it. And so I think that's how a movement, that's how a movement's launched, that's how a movement grows, and that's how a movement moves forward. But, as the tent becomes bigger, we are definitely more discerning about, what you've done in your life to demonstrate that you believe these things, not that you've shown up without a previous record and are telling me these things. That's just not going to fly. The other thing, too, is, as the movement gets bigger and more sophisticated, too, and, there's a lot of diversity of thought even within the conservative movement. And so this is another, I think, challenge for us to figure out, among the various perspectives on offer, which do we really want and believe in? that's something even within our own office that we're grappling with. As within the conservative movement, there is more debate and discussion about things. But that's just a function of success. That's a function of a growing movement with more people and more ideas. But I do think that's a challenge that we're trying to work through even today.
We've got about 10 minutes left, and we told you we'd save time for questions, so I assume there's microphones somewhere. Anybody has questions, come on up. My main job on this panel, aside trying to herd some of these cats, is to set the bar low so future panels don't have to do much better, and then also to finish on time. So we're going to do that. Yes, sir.
Yes, I'm Jake Wielden. I am currently the General Counsel for the Department of Business and Professional Regulations. So I work with Ryan all the time. So my question is, as an administrative practitioner, we deal with DOA all the time, which is, as you know, extremely different from your typical Supreme Court judge or DCAs, anything like that. And there's, in particular, maybe one or two ALJs who we've had some interesting decisions, I would say, from over the past few years. DOA judges are career service employees, so they have job protection. They're not subject to, any kind of, they never go up in front of a ballot or anything like that. So I just wondered if any of you had ideas on judicial reform as far as it reaches DOA and those type of positions that are really insulated from popular thought, where once you get on there, you behave good for a year, we may be dealing with you for life.
Who wants to take a stab at that?
Well, as an executive branch guy, I would like to remove the job protections. Whether that will ever happen or not, I have no idea. But it is a focus of ours to, when we have an opportunity to put people on, who share the appropriate philosophy for being on a court. I don't know if anybody else has thoughts on it.
So I actually had the opportunity to represent the Division of Administrative Hearings in a Public Employee Relations Commission case where they tried to discipline an ALJ, and I saw the full force of those career service protections that are afforded to administrative law judges, even ones facing a charge of insubordination to their superiors, which is it's certainly something that you would not expect to have to deal with when you're talking about the lawyers in the executive branch and other high-ranking officials. I think that the challenge there is trying to develop what is the balance there between the pure at-will employment and the idea that there will be some kind of an independent or quasi-independent adjudicator for some of the cases that come in front of the Division of Administrative Hearings. I obviously don't have a solution to that, but I agree with you. It's a real challenge because unlike a county judge, a circuit judge, a district judge, a Florida Supreme Court justice goes in front of the voters, and the voters can say no at some point. There really isn't a process like that for administrative law judges that in a lot of cases exercise much more significant authority in final order authority in a lot of executive branch cases that can be more significant than some county court judges have within their jurisdiction.
Rocky?
I have a view because I've had some experience in this area, and I think that one of the things that we need to remember is Amendment 6 to the Florida Constitution, which was co-authored by retired 3rd District Court of Appeal Judge Frank Shepard, who's here today, and Roberto Martinez, who Governor Bush mentioned earlier. And that means, it eliminated the Chevron doctrine in Florida long before the federal Chevron doctrine was addressed. And it says basically that there's no agency deference. But I think we've got a legacy of that in some way in Florida statute that allows agencies to change the legal conclusions of the DOA judges. And so when an administrative judge reaches a legal conclusion that the agency doesn't like, they can't change the fact findings, but they can change the legal conclusions. And I was on the losing end, at least up to now, of that challenge in a case. And I'm waiting to see if it gets teed up again in some way, or if the legislature will take it up, or a governor's office, and it's probably against the interest of the executive branch to do something like that. But I do think it's an anomaly in state law, and it could be now, part of the rub between some administrative judges and executive agencies. I don't disagree that, because I went through this as general counsel for Governor Bush, that there were some very, outcome focused administrative judges that we also had to contend with. So they never quite come out exactly as you want. But I wanted to bring that out because I think most conservatives believe in the elimination of the Chevron doctrine, and it's something that we as conservatives might want to look at again.
All right,
Thank you.
next question.
Eric Palmer. My question is for Ryan. As a also former Senate Judiciary person, I was struck by your remark that it might have been better if the founders had left advice and consent of the Senate out when it comes to judicial appointments, in particular because you and I both clerked for a guy who only made it to the court by virtue of some senators standing up to President Bush and saying maybe Harriet Miers is not a better pick than Samuel Anthony Alito Jr. for the court. And I wondered if you'd ever thought about it in, comparison with your kind of more general thought on the merits of the Senate's contribution to that process at the federal level.
Before I let Ryan answer that question, having spent close to a year and a half of my life waiting on the U.S. Senate to exercise its advice and consent authority, I would be more than happy that they have the timeframes that the state judicial process has. That was a miserable period of time. Thank you, Jeff Flake. But in any event, Ryan, what are your thoughts?
Judge, that's how clients feel when they're waiting for opinions. So just remember.
We can get those PCAs out a lot quicker. You don't like those either.
Well, I'm not saying don't do your job. I'm just saying do it fast. That's all.
Well, I mean, it is interesting that virtually every state, I don't remember what the numbers are right now, and every state's different, but virtually every state has rejected the founders' model for judges, and the framers' model for the federal government has been rejected in virtually every state, I believe.
Except
There may be a
New
handful.
Jersey has Senate confirmation, and it's caused a mess up there. I think they went without Supreme Court justices
Yeah.
for a long while.
And no offense to Judge Weatherall, I do think that there's an element of a federal judiciary run amok that's virtually uncontrollable at this point. That doesn't. I'm not suggesting, of course, that we go to maybe the Texas model where every judge is elected, but I do like having some moderate check on the judiciary. And here we have retention elections, of course, for DCA and Supreme Court judges. But I like the JNC process in the sense that there's some check on the governor up front. With an open process, JNC members who can, vet the candidates, ensure, some basic minimum standard of quality, and then the governor makes the appointment from the list. As long as the JNC bodies themselves are structured in a way that it's not controlled, and I agree with everyone up here that it would be nice just to eliminate altogether the bar's role in this process. But so long as there is, a properly structured JNC, then that is the upfront, check on the governor. But it seems to me like this process is a much better one for procuring a judiciary that is, philosophically appropriate. And I think, notwithstanding, that we have disagreements with the courts, I guess that just underscores that, they don't do just whatever the governor who appointed them expects, that they do exercise independence. but they are still all exercising the philosophy that we put them on the court to exercise. And so, yeah, I think there's a lot to be said for, what the states are doing, and that, as much as, I love the Federalists and whatnot, but maybe the Anti-Federalists were right about some things.
Thanks.
Any other questions? All right, well, like Lisa's coming up. I think we have hit our allotted period of time. It looks like 4 to 4:30 is a break and a book signing with Professor Calabrese and Professor Lawson, but Lisa will tell us for sure.
Yes, thanks to our panelists.